This is the Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner, host here on the Professional Edge. I appreciate you listening in, and guess what? This session we are going to talk about estate planning misses. And what does that actually mean? Individuals may have their estate plan or they may not have any estate plan, and we all know that 50% of our listeners here on the Professional Edge have no estate plan whatsoever, and we have not discovered the fountain of youth, so we all know that we are not going to make this out alive. So let's concentrate a little bit on estate planning misses. The reason why I say that is individuals, these are consequential mistakes, and these are things we can actually control. We've been focused a little bit lately on the economy and the high rate of inflation and the Fed rate changes. The Fed is still not done in our opinion. They probably have 2 more raises because the Fed is concentrated on bringing down inflation. But the effect on consumer spending and the control on inflation on food, we're not too in the same camp as the Fed on whether the interest rate rise is going to tamper inflation on food and energy. And that's a topic for a different discussion, but let's concentrate on the estate planning misses. The number one thing that we see is titles. That's where an individual looks at and says, okay, you did your house closing, and all of a sudden the real estate closing attorney says, hey, welcome to Georgia. You're from out of state. You know what? We need to do your estate plan, or we need to update your estate plan. And they do this nilly-willy estate planning organizer, and they collect some data, and wham, bam, boom, you have your new last will and testament. It is simple as can be, and it says, I give everything to my spouse, and if my spouse doesn't survive, I give it to my kids, and boom, sign it, and it's all effective. Well, guess what? If you go out on date night and you both pass away, then it's all going to go to the kids. And if you have minor kids, then it's going to go in trust for them until they reach the age of majority. And then wham, bam, the 18-year-old is going to receive possibly $500,000 if you have some life insurance and things like that, or that 401k. Then they, as an 18-year-old or 21, depending on the age of majority, is going to receive that $500,000. Now let's think about that. You being 18, step back in time, you receive a check for $500,000, $500,000. As an 18-year-old, we all know that that is not a very wise decision to give them a stick of dynamite that is worth $500,000. They may head off to the ski slope, or they may head off to Miami Beach in their new red Ferrari and press the self-destruct button. So that is one estate planning miss, that we do not actually plan for our potential minor beneficiaries. And that's where you can step over to emcadvisors.com. That is EMC, Echo Mary Charlie Advisors.com. And on the website, we have a ultimate estate planning guide that you are welcome to go to and receive. And it addresses why this is a miss. What we don't want to do is give our 18-year-old a stick of dynamite of $500,000 to blow themselves up. So what we do is actually inside that estate planning document, to avoid this estate planning miss, is set up what is known as a testamentary trust. That is basically a concept in the law which says testamentary says someone has passed away. That's the consequence. And when we have this consequence, then if we say that that beneficiary, meaning the minor children, is the beneficiary, we're going to not allow them unbridled access to this money, and we're actually going to place this in this testamentary trust. Give the trustee the discretion. That could be their uncle, could be an independent party, and allow them to administer these monies for that minor child, or even hold on to it until that beneficiary reaches the age of 30, and at which time they will receive 1/3, 35, 1/3, 45, the final balance. Now you say, oh, wait a minute, let's not control things from the grave. Well, you're not. What you're doing is guiding that minor beneficiary and having them be constructive with the funds based on an older individual, the wise counsel of that assigned trustee to that trust. So you don't hand them the stick of dynamite. It's okay to hand them a little bit of firepower, especially if it is going to be a productive use. For example, maybe a minor child and they want to go off to soccer camp. It is a flight away, it's a week away, and it costs $2,200. Well, guess what? The trustee says, hey, you know what? The minor child's parents would have wanted this. They would have done this. So let's go ahead and enroll that minor child in that camp and go ahead and disperse those monies. Also, if there's a car for high school, let's drive back and forth. We're not going to drive or provide a Ferrari to go back and forth to school. That is another recipe for disaster. But let's get them an F-150. It's going to be big, and therefore it's going to protect them in case of an accident, or at least that's the understanding. So that way the trustee has this discretion to dole out these funds for the benefit of the beneficiary and make more adult decisions with regard to the disbursement of those funds. If you don't have this in your estate plan, or you don't even have an estate plan, the place to start is give our office a call at 877-654-9798. That number again, 877-654-9798. And one of the ladies in the office will assist in scheduling that appointment. And you're welcome to come to our office in Columbus, or you are able to journey through the construction melee in Atlanta, or the advent of the Zoom meeting is pretty cool. Pretty convenient. I mean, all you do is establish that call. We have a conversation in the confines of your personal residence or office, whichever is most convenient to you. Gather some information, answer some questions, and see if we can, A, implement that testamentary trust for your minor beneficiaries. And you say, you know what, my son or daughter is over the age of majority. They are wise to what the individual is going to be able to do. They can handle that $500,000. Well, think for yourself. Even you right now may have never received $500,000 in a lump sum. Think about that. You receive that check today. What are you going to do? You're going to spend some. You're going to fritter some of that away. We're only human. So let's put that in that box. And the other benefit or estate planning miss that a lot of individuals don't take into consideration is, how do we protect our assets from creditors? So let's think about this. You passing this down to your children, how do you protect it from their potential creditors? Well, one planning opportunity is, again, this testamentary trust becomes creditor proof. And who is the largest potential creditor of your child? Well, guess what? It's an ex-spouse. And we already know that 1/2 of all marriages, and that percentage is going up, unfortunately, that half of all first marriages end in divorce. So we got a 50-50 chance. So if you're not driving and you're listening to this Professional Edge podcast or radio show, take out a quarter out of your pocket. Heads, we're okay. Tails, we have a divorce. That's a 50-50 split. Think about that. Flip that coin. Heads, oh, good. They survived that marriage. Flip it again. Heads again. All right, we survived. Flip it again. Oh, tails came up. Subject to the claims of that ex-spouse. So let's not even have that available. So let's just place this money in trust for your children, and therefore, underneath the guise of that testamentary trust, It would be creditor proof from the claims of that potential ex-spouse. Now, you say, I don't want to restrict my children. Well, if we draft that testamentary trust properly, you're not going to restrict them. All you're going to do is protect them and provide them with an asset protection tool. So if you don't have that in your estate plan, or you don't have a clue what you have, or it's just going outright to your children, this is the wake-up call for you to engage, or at least start the process to have a deeper conversation into how this might affect your own personal estate plan. The best way to start that conversation is to give our office a call at 877-654-9798. That number again, 877-654-9798. So these are these estate planning misses that individuals don't really comprehend. They don't see the full aspect of estate planning. And it's not that when you sign this document that you're going to pass away. It is, hey, I know I'm accepting reality. One day I'm going to pass away. And what is the best thing that I can do, A, for my surviving spouse and for my children? And if you are in a second marriage, this is even more important, because as we come back to that next episode, we're going to talk about what is the distribution strategy for your spouse or your second spouse. Again, if you're listening to this and you were one of those 50% people, the first marriage ended in divorce, and now you're in the second marriage. These blended families, her kids, your kids, and what is going to happen when one of you passes away. There is this dynamic of supporting your current spouse, but also to make sure that your surviving spouse doesn't continue on the marriage train and pick up husband number 3. So when we come back from break on this episode number 1 of Estate Planning Misses, we're going to talk about how best to leave things to that surviving spouse. Could be your husband 1 or wife number 1, or if you are into wife or husband number 2, H2, that's a Hummer truck, but we are talking about H2, husband number 2, or W2, that is wife number 2. So stay tuned here on The Professional Edge. My name is Sean Todd. I'm a tax attorney, CPA, and certified financial planner. And if you're leaving your stuff just outright to your kids, necessary call. It's my impetus to get you to plan to protect your hard-earned assets for your kids' benefits or your surviving spouse's benefit. The way to do that is give our office a call at 877-654-9798. That number again, 877-654-9798. Stay tuned. We have more coming up here on The Professional Edge.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA, for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.